Yesterday, a verdict was reached in the bench trial of Afro Audits, and we did get to see some of the paperwork, so I'll try and read some of it. So it's a State of Iowa against Casey Scott Van Neville. This matter came before the court on June 9, 2023 and August 8, 2023 for a bench trial on the state's trial information filed January 25, 2023, which charges the defendant with the offences of willful disturbance in violation of Iowa Code sections 718.3 and 703.1 in count 1, harassment in the third degree in violation of Iowa Code section 708.7 brackets 1 brackets B and 708.7 brackets 4 in count 2, and harassment in the third degree in violation of Iowa Code section 708.7 brackets 1 brackets B and 708.7 brackets 4 in count 3. The defendant was present without counsel. Ryan Decker, Assistant Lynn County Attorney, was present on behalf of the state of Iowa. Although originally only scheduled for a one-day trial, the matter could not be completed in the time allotted and was continued to a second day. The defendant previously executed 3 written waivers of jury trial, which were signed by the defendant and filed with the court on January 9, January 11 and January 27, 2023. The defendant also executed a written waiver of counsel, which was signed by the defendant and filed with the court on March 21, 2023. The defendant further orally waived his right to a trial by jury and right to counsel on the record after being advised of those rights, again by the court before the trial commenced on June 9th. The court also denied the defendant's oral motion for the undersigned to recuse himself from the bench trial for the reasons stated on the record. On the second day of the trial, the defendant made an oral motion to continue, which was resisted by the state. The court denied the motion, and the trial was ultimately completed that day. As set out in a separate order, the court found the defendant in contempt of court for misleading the court and needlessly delaying the trial that morning. And can't read the whole bit, but it appears there was no sentence issued for the contempt. Okay, that gives us a good summary. Just have a look at some of the detail. And we'll start at the top of this page, which obviously Casey says to the people he had the right to cuss them out. Again, this was not an isolated, brief incident, but instead lasted approximately an hour. Further, Ms. Williams and Ms. Hill were familiar with the defendant from prior encounters. Even though the office had gone paperless, one of the operators ultimately printed off a complaint form for the defendant in an attempt to defuse the situation. As of the second day of trial, August 8, 2023, no complaint form has yet been filed by the defendant. The defendant's behaviour, actions and encouragement of numerous phone calls to the Marion Police Department disrupted the functioning of the agency and its ability to receive and respond to legitimate emergency or non-emergency calls, to monitor and respond to radio traffic from officers, and to attend to other administrative responsibilities in a timely manner. While some parts of this recitation of the facts are certainly graphic and concerning, the court believes this written statement of facts pales into comparison to the same events as depicted in State's Exhibit 1. At no time while he was at the Marion Police Department on the date and time in question did the defendant ever report a crime or request any call for service from the Marion Police. Instead, the defendant asked for the window shade to be put up, for the operators to identify themselves, and for a complaint form. He was given an answer to each of those things. However, the defendant did not accept the answers he was given and continued to ask the same things and make vulgar statements. Okay, on to another bit. The credible evidence reveals that the Marion Police Department is a subdivision of an agency of the state as authorised by, at least, Iowa Code sections 80362 and 400. One of the duties of this agency is to receive calls for service, emergency and otherwise. Ashley Hill and Sarah Williams are employed by the Marion Police Department to take these calls for service and dispatch the appropriate responders. It goes without saying that these operators need to be available to answer any call for the service at the earliest possible moment. The evidence is further clear that on December 1, 2022, Casey Van Neville was at the Marion Police Department in Marion, Lynn County, Iowa. While there, he continually berated Ashley Hill and Sarah Williams with profanity and insults, making it hard for them to focus on their duties. He further repeatedly pressed the button requesting assistance from Ashley Hill and Sarah Williams at least 12 times for no real reason, thereby taking them away from the phones and their other duties. Lastly, the defendant encouraged his YouTube followers to call the Marion Police Department by giving them the number in a live stream and telling them to ask for the operators' names and to lift the shade. This resulted in 37 frivolous calls having to be answered during the time the defendant was there and for a period of time after he left. The evidence is clear that the defendant did not personally place the calls himself to the Marion Police Department. However, the evidence is equally clear that the defendant was fully responsible for all of the calls that were made. But for the defendant requesting his live stream viewers to call, none of those calls would have been made. Right, on to another bit. Secondly, the calls were only a part of the disruption to the communications operators. The defendant also pushed the button for service 11 to 15 times and remained in proximity of the operator's window, speaking loudly during his live stream for almost an hour. The court finds this somewhat analogous to the situation found in State v. Hardin. In that case, a person was charged with disorderly conduct for disrupting a speech by the President of the United States. While upholding his conviction, the Iowa Supreme Court found that even though attendees were standing and cheering during other parts of the speech, Hardin only interrupted the portions that were otherwise quiet and respectful, thereby removing any constitutional free speech protections he may otherwise have. Similarly, a larger volume of calls about an actual emergency may take a little more time for the dispatchers to sort through, but would be considered a normal part of the daily operations. Generally, such calls would be short, and after a few, the dispatchers would be able to inform subsequent callers about the same event that the matter was handled. However, calls about no real need for service made at the behest of the defendant only create extra work for no reason at all. The court further notes that several of the calls lasted a substantial amount of time, even though originated from outside of the Marion Police Department service area. As such, the court finds that the defendant's actions on December 1, 2022 willfully disrupted the functions of the Marion Police Department. Further, it seems even a minimal delay in the function of an agency can lead to a violation of this statute. And there's a reference to a case where the defendant's disrupting a meeting only lasted 1 to 4 minutes. Lastly, his actions and behaviour were tumultuous. Tumultuous does not appear to be defined in the Code of Iowa. However, according to the Encyclopedia Britannica, tumultuous means loud, excited and emotional. It further means involving a lot of violence, confusion or disorder. The court finds that Casey Van Neville's behaviour involves substantial confusion or disorder. The court finds that Casey Van Neville's behaviour involves substantial confusion as to his motives for such actions, disorder as to his offensive language and button pushing, and was loud and excited. His words and behaviour also caused Ashley Hill and Sarah Williams to be emotional and to have feelings of wanting to punch him because of his words and actions. Accordingly, the court finds that the state has proven beyond a reasonable doubt that Casey Van Neville committed the offence of willful disturbance in violation of Iowa Code. Section 718.3 on December 1, 2022 at the Marion Police Department in Marion, Lynn County, Iowa, when he willfully disrupted the functioning of an agency by his tumultuous behaviour. Okay, I thought it was interesting to read through those excerpts that I was able to decipher. He was obviously found guilty, I believe, of the 3 offences. The docket just shows that sentencing is to be held on the 21st of September. Thanks for watching.